Ladies and gentlemen, boys and girls, it's Diego. Welcome to another Green Card K1 Visa video. And this video is lifting the conditions off of your 2-year conditional green card, Mr. Beneficiary, Miss Beneficiary. But you have a child who also came into the United States with you under the K2 visa program. So how do you lift the conditions off of your child's K2 visa conditional green card? Can you do it? The question that I got from a subscriber was, can a K2 child lift the conditions off their 2-year green card with the same I-751 form as their parents? Well, this is a good news video. Okay, this is a good news video. Yes, a K2 visa applicant can have the conditions on their residency removed based on their parents' I-751 application, okay? But it is all based on critical things thus. So pay attention, class, okay? The K2 child can be included in the parent's application under these certain circumstances. Otherwise, they must file a separate petition, okay, separately. So this is how a child can be included. They can joint file with their parent, okay, to be included in the parent's joint form I-751 petition, which is to remove conditions on a residency. The K2 child must meet one of the following criteria. The child received their conditional permanent residency status on the same day as their K1 parent. You can look at the 2-year green card, check the issue dates. The child received their conditional status within 90 days after their K1 parent. Look at your 2-year green cards, mother child, father child, check the issue dates. So in this scenario, the parent includes the child's name, and don't forget, include the alien registration number in Part 5 of the parent's Form I-751. Okay? Now, when does a child have to file separately? Well, a K2 child must file their own separate Form 751 under these circumstances. The child acquired conditional residency status more than 90 days after their K1 parent. Check the issue date on the green card. The K1 parent has passed away. So, filing the I-751 waiver. Okay, if the K1 parent and their U.S. citizen spouse cannot file a joint petition to lift the conditions on the child's 2-year green card, the K1 parent may apply for a waiver. So there's always a waiver for something, right? And this would include cases involving like abuse or extreme cruelty. So a K2 child may also be included in this waiver petition. So the K1 visa and the K2 visa beneficiaries no longer are with the U.S. citizen sponsor. A K2 child can also file their own waiver petition if the parent is unable to or is unwilling to file one on their behalf. But here are some important things that you got to think about. Age is out. The Child Status Protection Act, the CSPA, can provide protection if the K2 child ages out by turning age 21. If the K1 parent and U.S. citizen marry before the child turns 18, a step-parent-child relationship is established and CSPA can apply. Okay? Evidence. Well, immigration always want evidence. The K2 child's case depends on proving the marriage between the K1 parent and the U.S. citizen was entered in good faith, and evidence such as joint bank accounts, shared property, and other documents must be provided. So what is the timeline? The Form I-751 must be filed within the 90-day period before the conditional green card expires. Look at the expiration dates on the green cards. If a filing waiver, if you're going to file a waiver, it can be filed at any time before the status expires. Okay, now, how much is all this going to cost? Well, the cost as of September 3rd, 2025 is $750 to lift the conditions on a K1 visa applicant's 2-year conditional green card. If you include a K2 child in your paperwork under age 21, In Part 5 of Form 751, it is an additional $85 per child to cover the biometrics cost, the fingerprints, etc. So that would be $750 plus $85 per child included on your Form 751 in Part 5, when the parent K1 is lifting the conditions on their 2-year green card and includes the child under age 21. So to pay for these USCIS fees, you will need to use the following forms. Form G1650. This form allows you to authorize direct debit payments from a U.S. bank account for immigration fees. You can submit this form with your application or petition. Number 2, you can use Form G1450. G1450. This form is used for credit card payments for immigration fees. I don't recommend you use your credit card to pay for any immigration fees. Most banks don't recognize the charge and you get in a problem. And paper payments, you can use a check or a money order, but those will only be accepted until October 28, 2025. After October 28, 2025, only debit and credit card payments will be accepted on those 2 forms that I mentioned. Make sure you submit the correct fee with your application to avoid rejection. I'm not an immigration attorney. I give you no legal advice here, and I don't work for USCIS. But thanks for watching, and we will see you at the next live stream, which are Mondays, Wednesdays, and Saturdays at 6 p.m. Central Time. Or now you can also sign up as a member to this channel. If you want to get my cell phone number and email address for a direct contact to me, so I can help you 7 days a week with your immigration K1 visa, your green card application, your K1 visa application.